Deemed supply. Article 11. The cases of deemed supply. The following cases shall be considered as deemed supply. 1. A supply of goods or services, which constituted the whole assets of a taxable person or a part thereof, but are no longer considered to be as such, provided that the supply was made without consideration. 2. The transfer by a taxable person of goods that constituted a part of his business assets from the state to another implementing state, or from the taxable person's business in an implementing state to his business in the state, except in the case where such transfer a. is considered as temporary under the customs legislation, b. is made as part of another taxable supply of these goods. 3. A supply of goods or services for which input tax may be recovered but the goods or services were used in part or whole, for purposes other than business, and such supply shall be considered as deemed only to the extent of the use for non-business purposes. 4. Goods and services that a taxable person owns at the date of tax deregistration. Article 12. Exceptions for deemed supply. A supply is not considered as deemed in the following cases. 1. If no input tax was recovered for the related goods and services. 2. If the supply is an exempt supply. 3. If the recovered input tax has been adjusted for the goods and services pursuant to the capital asset scheme. 4. If the value of the supply of the goods, for each recipient of goods within a 12-month period, does not exceed the amount specified in the executive regulation of this decree law, and the goods were supplied as samples or commercial gifts. 5. If the total output tax due for all the deemed supplies per person for a 12-month period is less than the amount specified in the executive regulation of this decree law.